You don't have any sort of an estate plan in place, we can have a whole bunch of unintended consequences when it comes to your house, your money, your business, whatever assets that you have. Quite frankly, if we don't have any plan in place at all, state law governs what happens to certain assets. So if there's an asset like a business that's just in your name, or like your home that you don't have a spouse or somebody on with you, North Carolina state law is going to tell us where those assets go. And most people think that if they're married, everything just goes to their surviving spouse automatically. But in North Carolina, if you don't have a clear estate plan that tells us that, your spouse and your children might wind up sharing some of these assets as a part of the estate. We have to be really careful when we set these things up, and we have to make sure we're defining who those beneficiaries are. So if you pass away and you own a business, a lot of times your business itself is considered personal property. And the first thing that tells us is that we have to go through probate in order to distribute that to somebody else. If you don't have a plan, a will, a trust, or something that tells us who that beneficiary is, that business could wind up being split between maybe a spouse and children, or if you don't have children and parents are living, things get really complicated. So it could wind up in a number of different ways that don't line up with what you want to see. So if we want to unpack that, we should talk about it. Overall, we always want to make sure that we have some kind of succession plan in place, whether that's for just your personal assets or for any business assets that you have. And when we talk about a succession plan, we have to talk about who receives the asset itself. That's going to be your beneficiaries or successor beneficiaries. And then who controls that asset. And that can be your executor, a trustee, successors for those various roles as well. But the bottom line is we really just have to talk about it. If we have to decide who's going to control things, who's going to receive the benefit of these assets that you leave behind. All of that together makes a complete estate plan. So we have to differentiate a little bit between a successor executor and a successor beneficiary. Really, a beneficiary at the end of the day is who receives the benefit of the asset itself. And an executor is who carries out or controls that asset while it's being administered through a probate process. Sometimes we also have a trustee in place that handles these types of things outside of probate. But an executor, they're not given a tremendous amount of discretion. They have to make sure that the beneficiary ultimately receives the benefit of the asset we're talking about. But in most cases, although an executor isn't given a lot of discretion, you also have picked somebody you trust to carry out this administration of your estate. The best way to make sure that courts and North Carolina law doesn't get to decide where your estate goes is for you to decide yourself. And the easiest way for you to do that is to have some kind of an estate plan in place, whether that be a simpler last will and testament, a revocable trust, or one of the many other types of planning tools that might be out there. If you have a last will and testament but don't have a revocable trust, there may be some unintended exposure to the probate process. Certain things will pass through joint ownership or through beneficiary designation, but one of the biggest reasons that we used revocable trust is to create a probate avoiding tool that covers a whole lot more assets. If we're exposed to the probate process because we haven't included something like a revocable trust as a part of your plan, there's other types of costs that are associated with that. Probate in North Carolina charges a transfer fee for assets that go through the probate process. So although you might save a little bit of money on the front side by doing a simpler will, there might be some unexpected costs down the line when it comes time to transfer those assets to the intended beneficiaries. Cost of probate can really add up quickly. North Carolina charges roughly about $4 for every $1,000 that goes through that proceeding. There's some caps in place that we have to be aware of, but the bottom line is those costs could be avoided with proper planning. If you pass away and you don't have an estate plan in place, there could be a whole host of problems. So the easiest thing to do is to take the time now to set up a plan, to talk through your wishes, talk through who those beneficiaries should be, and NC Planning would love to help you with that.